How much does probate cost in Florida? Does probate always cost thousands of dollars? Who pays the probate attorney? What fees come out of the estate? And are there ways to reduce probate costs? These are some of the most common questions I hear from families after the loss of a loved one. Unfortunately, there's a lot of misinformation about probate costs. Some people believe probate always costs tens of thousands of dollars, and others think beneficiaries have to personally pay probate expenses out of their own pocket. The truth is much more nuanced. The cost of probate depends on several factors, including the type of administration, the assets involved, whether real estate is part of the estate, whether creditors exist, and how complicated the administration becomes. In this video, I'm breaking down the complete guide to Florida probate costs, including court costs, attorney's fees, personal representative compensation, creditor claims, appraisal expenses, publication fees, and the factors that can significantly increase or reduce the overall cost of probate. By the end of this video, you'll understand what drives probate costs and what families can do to avoid unnecessary expenses. What determines probate costs in Florida? One of the biggest misconceptions about probate is that every estate costs roughly the same amount to administer, and that simply is not true. Probate costs vary widely depending on the complexity of the case. Some of the biggest factors include whether the estate qualifies for summary administration, whether formal administration is required, the value of the estate, the number of beneficiaries, whether real estate is involved, whether creditor claims exist, whether there are business interests, whether property is located in multiple states, and whether title issues have to be resolved. For example, imagine two estates worth exactly $300,000. The first estate contains one bank account, one beneficiary, no creditors, and no real estate. The second estate contains a Florida home, 3 beneficiaries, a mortgage, multiple bank accounts, and several creditors. Although both estates are worth the same amount, the second estate will generally require significantly more work to administer. And this is why probate costs can vary substantially from one case to another. Court costs in Florida probate. Every probate case involves court costs. These are usually the first expenses incurred when a probate case is opened. Court costs can include filing fees, certified copies, recording fees, additional pleadings, and court-certified documents. The exact amount depends on the county, type of probate administration, and the filings required. Many families are surprised to learn that court costs are often one of the smaller probate expenses. While they're necessary, they're usually not the primary factor driving overall probate costs. But still, they are an important part of the administration process and should be expected whenever probate is opened. Attorney's fees in Florida probate. Perhaps the most common question I receive is, how much does a probate attorney cost? Florida law provides guidance regarding reasonable compensation for probate attorneys. However, there's no one-size-fits-all answer. Attorney's fees often depend on estate complexity, the number of assets, real estate involvement, creditor issues, number of beneficiaries, required court filings, and the overall time involved. For example, a straightforward summary administration involving one bank account may require significantly less work than a formal administration involving multiple properties and numerous heirs. Many people are relieved to learn that probate attorney's fees are generally paid from the estate assets. The attorney is not simply filling out paperwork. A probate attorney often helps open the probate estate, prepare court filings, address creditor issues, coordinate asset transfers, resolve title concerns, guide the personal representative, and ensure proper distribution. The more complex the estate becomes, the more legal work is often required. Who pays probate costs? This is another area where many families become confused. Generally speaking, probate expenses are paid by the estate, not by the beneficiaries personally. Probate expenses may include court costs, attorney's fees, personal representative compensation, publication costs, appraisal fees, and accounting fees. These expenses are typically paid before distributions are made to the heirs or the beneficiaries of the estate. For example, if an estate contains $250,000 in assets and administrative expenses total $15,000, those expenses are generally going to be paid first. The remaining estate is then distributed according to the will or Florida law. This is an important distinction because many families worry that they need to personally fund the probate process. In many cases, that's not how probate works. Does the personal representative get paid? Yes. Florida law generally allows a personal representative to receive compensation for administering an estate. The personal representative has significant responsibilities. These responsibilities often include gathering assets, managing accounts, communicating with the beneficiaries, working with attorneys, reviewing creditor claims, maintaining property, and distributing assets. Serving as personal representative can require substantial time and effort. For that reason, compensation may be appropriate. That said, many family members choose to waive compensation. For example, if an adult serves as a personal representative for a parent's estate, they may decide not to seek compensation. Others may choose to accept compensation because of the amount of work involved. Every situation is different. Additional probate costs families overlook. Many people focus only on attorney's fees, but there are several other expenses that frequently arise during probate. These may include publication costs. Formal administration generally requires publication of a notice to creditors. Publication carries a separate expense. Appraisal costs. Certain assets may require valuation. Examples include real estate, businesses, collectibles, and valuable personal property. Accounting fees. Complex estates sometimes require accounting assistance. Property maintenance. Vacant homes may continue generating expenses such as utilities, insurance, lawn maintenance, HOA dues, and taxes. These expenses can accumulate quickly during administration. How real estate increases probate costs. Real estate often creates additional probate expenses. Why? Because real estate frequently requires additional work. Examples include title review, homestead determinations, mortgage issues, property maintenance, coordination with title companies, and real estate transfers. Let's look at a common example. Imagine 4 siblings inherit a Florida home. One sibling wants to sell, and one wants to keep the property. Another wants to rent it, and one refuses to cooperate. Now, additional time and effort may be required to resolve ownership issues. This is one reason probate involving real estate is often more expensive than probate involving only financial accounts. How creditor claims affect probate costs. Creditor issues can significantly affect probate expenses. During probate, creditors may file claims against the estate, and these claims often require review, investigation, documentation, negotiation, and possible court involvement. For example, suppose the decedent had medical bills, credit card debt, and personal loans. The personal representative and attorney may need to evaluate those claims and determine how they should be handled. The more creditor issues that arise, the more work may be required during administration. Real-world probate cost examples. Let's look at a few practical examples. Example 1, simple summary administration. An individual passes away, leaving one bank account, one beneficiary, no creditors, and no real estate. This type of estate may qualify for summary administration and is generally one of the least expensive probate scenarios. Example 2, formal administration with real estate. An individual leaves a Florida home, 2 children, and several financial accounts. Now probate becomes more involved. The personal representative may need to address title issues, transfer ownership, and coordinate distributions. Additional work often increases administration costs. Example 3, complex estate. An individual owns multiple properties, business interests, investment accounts, and assets in more than one state. The estate also has creditors and multiple beneficiaries. This type of administration often requires significantly more legal and administrative work. As complexity increases, costs generally increase as well. The cost of delaying probate. Many families delay probate because they're worried about expenses. Ironically, delaying probate can often create additional costs. For example, a vacant property may continue generating property taxes, insurance premiums, HOA fees, utility bills, and maintenance costs. Meanwhile, the property may deteriorate, the title issues become more difficult, and financial institutions may continue restricting access to accounts. Starting probate promptly often helps prevent these unnecessary expenses from accumulating. How estate planning can reduce future probate costs. One of the best ways to reduce future probate costs is through proper planning. Potential planning tools include revocable living trusts, beneficiary designations, ladybird deeds, and proper asset titling. The goal is not necessarily to avoid probate at all costs. The goal is to simplify administration and reduce unnecessary complications for loved ones. Good planning often results in a smoother and more efficient administration process. Common probate cost myths. Let's address a few common myths. Myth number 1, probate always costs tens of thousands of dollars. Well, that's not true. Many probate estates are relatively straightforward. Myth number 2, beneficiaries personally pay probate attorney's fees. Typically, estate assets pay probate expenses. Myth number 3, every estate requires formal administration. Some estates qualify for summary administration. Myth number 4, a will avoids probate. A will directs how assets are distributed through the probate. I actually refer to it as the roadmap for your probate case. It does not automatically avoid probate. Understanding these distinctions helps families make informed decisions. When should you speak with a Florida probate attorney? If you're concerned about probate costs, speaking with a probate attorney early can be extremely helpful. This is especially important when real estate is involved, multiple heirs exist, creditors are involved, business interests exist, and assets are located in multiple states. Early guidance often helps families avoid delays, mistakes, and unnecessary expenses. Hi, I'm Alicia C. Daniel, Trust, Estate, and Probate Attorney at Genesis Law. If you need help understanding the costs associated with the Florida probate matter, click on the link in the description box and select Schedule a Consultation.